గారి చేతుల మీదుగా సన్మానం.
భారత ప్రభుత్వంలో అనేక ఉన్నత పదవులను నిర్వహించి 50వ ఏటనే కేంద్ర ప్రభుత్వ కార్యదర్శి కావడం, 6 ప్రధానమంత్రులకు న్యాయశాఖ కార్యదర్శిగా న్యాయ సలహాలను అందించడం, పురపాలక గ్రామ పంచాయతీలలో పటిష్టమైన ప్రజాస్వామిక వ్యవస్థను నెలకొల్పడం కోసం నాటి రాజీవ్ గాంధీతో 10 మార్లు మాట్లాడి భారత రాజ్యాంగంలో అధికరణాన్ని పొందుపరిచేటట్లు చేయడం, మన తెలుగుదేశాన్ని దేదీప్యమానం చేసిన నాటి ప్రధాని పివి నరసింహారావు గారికి సలహాదారుగా అత్యంత సమర్థవంతంగా సేవలు అందించడం, 1972 పాకిస్తాన్ 2గా విడిపోయినప్పుడు పాక్ ఓవర్ఫ్లై వివాదాన్ని లేవనెత్తినప్పుడు భారతదేశం తరఫున అంతర్జాతీయ న్యాయస్థానంలో వాదించి పాక్ వాదాన్ని తిప్పికొట్టడం, ఐక్యరాజ్య సమితి అంతర్జాతీయ న్యాయ సమ్మేళనంలో 10 దేశాల ప్రతినిధుల చేత 3 సార్లు అంటే మొత్తం 21 సంవత్సరాలు అంతర్జాతీయ లా ట్రిబ్యునల్ అధ్యక్షులుగా ఎన్నుకోబడడం, పిసి రావు గారు మాత్రమే సాధించిన అపూర్వ అంతర్జాతీయ విజయం. భారతదేశానికి ముఖ్యంగా తెలుగు వారికి గర్వకారణం. మన న్యాయశాస్త్ర కోవిదిని విజయ పరంపరా తోరణం. ఆయన రాజ్యాంగ, న్యాయ, మానవ హక్కుల పరిపాలనా రంగంలో నిపుణులు. 50కి పైగా అంతర్జాతీయ సదస్సుల్లో పాల్గొని ప్రసంగాలు చేసి న్యాయ విశ్లేషణను గొప్పగా కాల్చినటువంటి మహనీయులు. వారిని ఇప్పుడు కింద తరఫున పెద్దలు సత్కరిస్తారు. ఐ రిక్వెస్ట్ ఆనరబుల్ చీఫ్ జస్టిస్ టు గార్నింగ్ హిమ్ అండ్ హెల్ప్ హిమ్. ఐ ఆల్సో రిక్వెస్ట్ ఆల్ ది జడ్జెస్ టు జాయిన్ ఇన్ ఆనర్ హిమ్. రఘురామ్ గారు సన్మాన పత్రం ఇస్తారు. మన రామానుజన్ గారు వారిని సత్కరిస్తారు. అలాగే రమణ గారు ప్రత్యేకమైన గిఫ్ట్ని ఈ సందర్భంలో వారికి అందిస్తారు. ఆయన ఉస్మానియా యూనివర్సిటీలో లాలో విజిటింగ్ ప్రొఫెసర్గా ఉన్నారు. అనేక న్యాయశాస్త్ర గ్రంథాలు రచించారు. పంతొమ్మిది 1996వ సంవత్సరంలో ఆయన అంతర్జాతీయ ట్రిబ్యునల్లో అధ్యక్షుడిగా అయితే అది 2017వ సంవత్సరంలో ముగుస్తుంది. దయచేసి గమనించండి. అంటే ఇక ముందు 5 సంవత్సరాల పాటు ఆ ఇంటర్నేషనల్ కోర్ట్ ట్రిబ్యునల్లో ఆయన జడ్జిగా ఉంటారు. కిన్నెరా ఆర్ట్ థియేటర్స్, హైదరాబాద్. పెద్దలందరినీ ముందుకు వచ్చి జడ్జి గారు రామానుజన్ గారిని, రమణ గారిని ముందుగా జడ్జిలు రామారావు, బహుశా మనందరికీ కూడా వారి యొక్క ఔన్నత్యం తెలియదు. ఇటువంటి సన్మానం ద్వారా మనకి వారి యొక్క గొప్పతనం తెలియడమే కాకుండా తెలుగువారు అంతర్జాతీయంగా ఎంత ఉన్నత శిఖరాలకు వెళ్ళగలరో మనం అవగతం చేసుకోగలుగుతున్నాం. వీఆర్ గ్రేట్ఫుల్ టు అవర్ ఆనరబుల్ చీఫ్ జస్టిస్ అండ్ వీ హ్యావ్ రిసీవ్డ్ ఏ బ్యూటిఫుల్ కన్సెప్ట్. ఇలపాట విజయ శివప్రసాద్ గారు వాళ్ళ వేదిక మీదకి వచ్చి చీఫ్ జస్టిస్ గారి చేతుల మీదుగా సత్కారం అందుకోవచ్చుగా కోరుతున్నాం. Sir, he was honored by the Prime Minister Indira Gandhi and consecutive Prime Minister of India. He toured all over the world and gave consult to the delight of the art lovers. I request him to honor all these. Now we honor our Chief Justice. Just go beyond the legal procedures and keep social service in their mind. Perhaps a unique expression of a Chief Justice. I request our Chief Justice to honor our Prabhakara Jindari, our Prabhakara, Alaji Raghuram Gandhi. Bodulu Ramarao, he project, he has carved out the idea about this.
Honorable Chief Justice of Andhra Pradesh High Court, Sri Madan Lokor, Honorable Justice Ramanjam, Honorable Justice Raghuram, Honorable Justice N.V. Ramana, Sri Prabhakar Rao, Chairman of this foundation, this organization, Bodulu Ramarao, Raghuram, Madali Raghuram. Our distinguished friends, let me at the outset say a few words about the Honorable Chief Justice and the other judges who are on the dais today. A lot of praise has been showered on me. Of course, on occasions such as this, perhaps exaggeration is permitted to some extent. And of course, coming as they do from judges, I always treasure them. Sri Madan Lokor is known to me, as he put it, since 1970, I think, 1970 or 72. His father was my predecessor in the Ministry of Law, B.N. Lekor, a very distinguished law secretary. By the time, of course, I joined the law ministry, he had gone, he retired, but established a very sound name in legal circles. So I have come to know Sri Madan Lokor as the son of a former colleague in the law ministry, my predecessor. And I found him to be very simple, direct, and transparent in what he does. As a young man, he attracted my attention, and I knew at that time itself that he would rise to important positions, to judgeship, Chief Justice position, and soon judgeship for the Supreme Court of India. We should all be proud of the achievements he made in the short career as a judge and as the Chief Justice, and you have been, though I have not been in Hyderabad ever since he came here, excepting for a few days, you have all seen him, his actions, his activism in going to district headquarters, setting things right, and so on. And I have no doubt that his rise to the Supreme Court will be a welcome development. Hopefully, he may even end up as the Chief Justice of the Supreme Court. I have known Justice Raghuram for a fairly long time. Again, I think for the last 20 years or so. He's a scholar, and you have seen his judgments written in a very scholarly manner. And he's a person who has sound understanding of the jurisprudence of law. And Justice Ramana, of course, is like a family member to me. I've known him as a young boy in the University of Nagarjuna University. In fact, as a young student, he met me. I was addressing the Bar Association of Andhra Pradesh, Bar Vijayawada. Came and met me and said, "Sir, I want you to come to our university and deliver a lecture." And since then, he has attracted my attention as a very bright boy. And later on, of course, as you all know, you followed his career. He has established a very good name, and I'm very glad of his developments, of his career developments. He will soon be going as the Chief Justice of another High Court. And in time to come, he will be elevated to the Supreme Court of India. Perhaps, so you will see two distinguished judges of the Supreme Court on the dais now. I am thankful to the organizers for inviting me. This is the first time I have come to Ravindra Bhavan. Though I've been living here for so many years, this is the first time I was actually looking for the hall where I should go when I entered this building. A lot of people do not know as to what I do. Some sort of an esoteric subject, international education. They do not know what I do. Of course, I was law secretary for well about 8 years, served 6 prime ministers, all that stuff. But in 1996, the then Chief Minister, Prime Minister P.V. Narasimha Rao, nominated me as India's candidate for judgeship in this international court. Then soon after that, he ceased to be the Prime Minister. So at the time of my election, actually, he was not the Prime Minister. The file was again put to his successor for his approval, because this sort of appointments are done with the approval of the Prime Minister. And Devi Gowda was the Prime Minister and he approved. So I got elected, and the country, the importance of being nominated by your country is that your country, through its embassies, approaches different governments, because states vote in the UN. So they do a whole lot of work, and I got elected at that time for a 3-year period. But normally, generally speaking, the term of an international court is 9 years. Only the first time they choose some judges for 3, some for 6, some for 9. Then in 1999, Vajpayee again re-nominated me as India's candidate, and I was elected again for a 9-year term. And more recently, the present Prime Minister also, though his government, his External Affairs Ministry suggested that Dr. Rao has become fairly old now, he need not be re-nominated because he had done 2 terms, already 12 years, and should not be nominated. That was the recommendation of the Ministry of External Affairs. It went to then Foreign Minister, Pranab Mukherjee, and he said, "Where is Rao? I want to see him." I don't go to any politician, then or now. That's not been my habit. So I was summoned to Delhi, and when I went there, he was in the Minister of External Affairs. He says, "The Prime Minister and I would want you to again contest for the election for a 9-year period." So he overruled his ministry, and I was nominated by him and received the approval of the present Prime Minister, whom I know very well, as the Finance Minister for 5 years under P.V. Narasimha Rao. So therefore, it's not as if I belong to one party or other. Shri Narasimha Rao, Shri Vajpayee, Shri present Prime Minister, all of them, it's a great honor that they still recognize me. And this particular award given to me, Padma Bhushan, after 15 years I ceased to be a government servant, is also a recognition that my services have not been forgotten by the government. But that apart, I want to say a few words about this tribunal, because you would not know what is this, what does it do. The International Tribunal is a world court, but its jurisdiction is confined only to law of the sea matters. Anything concerning oceans, navigation, fisheries, security, delimitation, all these problems will be coming to our court, which is a specialized international court dealing with law of the sea. And the persons who are elected to this tribunal from different countries were all there at the time when the convention was being drafted. From 1970 till 1976, I represented India in the Law of the Sea Conference. I was elected as a judge not because I happened to be a law secretary, but because of my expertise in the field of law of the sea. I represented India in all those meetings, so all the judges are experts in the law of the sea. Now, this is a world court which decides disputes between states. I'll tell you, the very recent case, last month we decided a delimitation dispute between Bangladesh and Myanmar in the Bay of Bengal. In the Bay of Bengal. I find it unfortunate that newspapers in our country, as in any other country, do not seem to evince any interest in international adjudication. They do not know what we do. This judgment which we gave settled a dispute between Bangladesh and Myanmar. Similarly, India also has a dispute with Bangladesh. So what we decided in the case between Bangladesh and Myanmar will also be of direct importance to India's dispute with Bangladesh, which is soon going to be decided again. Is one. The other one is, I'm giving you a few examples from our region, because we decide disputes arising from all over the world. Between Australia and New Zealand on the one side, and Japan on the other side, in bluefin tuna, matters relating to bluefin tuna. I'm a vegetarian. I don't know. I don't eat fish. Now, I believe each fish, bluefin tuna, will cost you $50,000 dollars. Each fish. It's a very interesting fact, actually. A fish costing $50,000. That is that important. It's a delicacy, I am told. So, there was a dispute between Japan. Japan is the major fish-eating country. Australia and New Zealand contended that this fish was being overexploited by Japan, and therefore preventive action should be taken. We have resolved that dispute. And more recently, a dispute between Singapore and Malaysia. Changi Airport, those who have gone to Singapore perhaps have heard of Changi Airport. That's the airport at which you get down to arrive at Singapore. They were wanting to enlarge the airport. So they claimed additional sea area, and Malaysia said that this is an encroachment on its own territorial waters. And then this project disturbs environmental factors. This dispute also we have resolved now. So, I mean, you can now see the type of disputes that we settle from different parts of the world. Now, how do you get elected? I told you. A government has to nominate you as a candidate, and then elections are held. States put their votes, and you have to get at least 3/4 of the vote cast. A very tough procedure. But anyhow, India has been always taking great interest in the elections, and we were able to win the battle. In fact, I got the maximum number of votes. I was then elected as the president of the court in 1999. After the end of the 3-year period, I again contested the election and got a 9-year period. In the beginning of that year, 1999, I was elected as the president of the court. President means Chief Justice. In international courts, the name given to the head of that body is not Chief Justice as here, but the president of the court. I was elected as the president. I served as the president from 1999 to 2002. So, you know, at least now you know what sort of activities we deal with, and then we administer international law of the sea, international law in general, not municipal as such. Though, in writing the judgment, I have taken examples from municipal jurisprudence when I don't find equivalents in the international adjudication. In fact, I have prepared the guidelines for the court for the presentation of cases, and I was inspired by the Supreme Court Code of Conduct. Actually, I borrowed heavily from that, and I explained this in the articles that I wrote. So, though I have been dealing for the last 15 years with the international law, law of the sea, etc., I have not forgotten my constitutional law background. I have advised the 6 governments, 6 prime ministers in constitutional matters. Therefore, I was occupying an advantageous position so far as constitutional law is concerned. So, I'm part of constitutional law making, part of constitutional advising, so on and so forth. So, now today, I would like to draw your attention to 2 aspects. I will take not more than 15-20 minutes because it's not a forum for delivering a full-length lecture on the Constitution in action. But I would like to draw your attention to two things. One, separation of powers. The second, center versus the state. You know, in 1950, when the Constitution was enacted, separation of powers is an essential feature of the Constitution. In other words, the executive, the legislative, and the judicial wings enjoyed powers, but in their respective fields. So there is separation, broad separation of powers, not in the strict sense, in the American sense, but we still had. At that time, it was felt that the judicial wing was the junior partner. The judicial wing was the junior partner in the 1950s and 60s. The executive was more prominent. Today, what is the position? There's a U-turn. It's the judiciary which is the controlling organ here now of the three bodies. And thanks to the role that it has come to play, democracy is still functioning in this country. I'll come to that a little later. In fact, I consider that the Supreme Court, of all the national courts, our Supreme Court is the most powerful body in the world. I'm not commenting whether this is a desirable development or otherwise. I'm only stating the facts. In the very beginning, in the first 2 decades, courts went by the language employed in the Constitution, and therefore, you haven't found court decisions which stretch the scope of law, enacted law. But what has happened? The court found somewhere in the first 3 decades, after the first 3 decades or so, that the Parliament was amending the Constitution, perhaps in an indiscriminate manner. And that this could lead to abrogation or abridgment of fundamental human rights and other essential features of the Constitution. Therefore, the court, here comes the activism, judicial activism. Court held, of course, Parliament is the body which can amend the Constitution, but the court held in this case that there are a number of essential basic features of the Constitution, which includes the separation of powers, democracy, independence of judiciary, which cannot be affected even by an amendment. So therefore, it's sort of a check on the amending power of Parliament, done in the interest of, let's say, survival of democracy. That is one. And second, they even held that judiciary can legislate till the field is occupied by the legislature. So you have these sort of things happening, and they've also given judgments which involve expenditure. They have also commented upon activities within the legislative, within the four corners of the legislature. So I'm not going to enumerate all of them. So in other words, they say if the separation of powers has taken a beating in relation to the legislative powers. Similarly, in the executive field also, you know that no government can survive without having some discretionary powers or the other. This has to be admitted. But unfortunately, our executive, whenever you give them discretionary powers, there is a likelihood of an abuse, and in fact, abuse was found in several spheres of executive action. So the court then wanted to curtail these evolved principles of administrative law, which limit the exercise of discretionary powers. Then they also interpreted the Constitution, particularly fundamental rights, articles 14, 19, 21, and so on. And the present position is that you can't turn left or right, which cannot be challenged in a court of law. This is in essence, in practical terms, you have transferred an officer, the matter is taken to the court, and you are answerable to the court. Unfortunately, the position is, when I became the law secretary, I saw the situation. The question is not whether you like the judgment. The question is, there is no option to you. The courts have held so. They have interpreted the Constitution, other laws. You have to follow them until these decisions are overruled or whatever. So when I joined as a law secretary, I saw that in fact, I can tell you one thing. No prime minister knows constitutional law. No prime minister knows constitutional law. No chief minister, for all the more reason. They don't even bother, about the constitution. So in that context, what was my duty? I refer to this development because you should know that I played in what I consider to be an important role at a critical juncture when courts are interpreting law in a particular direction and the executive is not paying heed to them, and therefore you come to grief in court of law. This is a democracy. In a democracy, the courts tell you what can be done, what cannot be done. Therefore, I entered the field, and then Sri Rajiv Gandhi at that time was looking for a law secretary who could advise him in relation to panchayats and municipalities. There were 15 or 16 sittings with him by me. At the end of it, he said, Dr. Rao, you have made me half constitutional lawyer. So, then after that, of course, came the Chief Justice said, the governments of few months, Vishnapatha Singh, Chandrasekhara, and then came Narasimha Rao. The first person whom he invited to come to his office when he became Prime Minister was Dr. Rao. Because he saw me playing a very crucial role when Rajiv Gandhi was allowing me to speak in the cabinet and to deal with matters like that, etc. From then onwards, I've established a very close relationship, though not from a personal angle, but from an official. In other words, he did not do anything at all without first discussing the legal implications. That's the greatness of P.V. Narasimha Rao. Not many chief ministers now will observe these principles, therefore they come to grief. So as I think the other judges said, I've always been blunt. I speak in the cabinet in a blunt manner. I've never tried to compromise. I have confidence in myself. I've studied constitutional law in the proper sense, and it is my duty. I'm the highest paid civil servant. It's my duty to tell the government what is wrong and what is right. I did this in a very frank manner. P.V. Narasimha Rao put me on the top of his head because of that feature. He would ask whether Dr. Rao has seen a particular thing. If they say that he has seen this, he will simply sign. That amount of confidence is developed in me. It's very important now, if there are any ministers here, they should notice it. Why are you coming to a grief on account of court decisions? Because you don't pay any attention to what they are saying. Question is not whether what they're saying is sound. If that is not sound, you should challenge it. But you cannot go and ignore them. It's very important. You should have a person with a backbone to tell you whether you are right or wrong. You got to find that type of officer. In the other day, Prime Minister also was making a statement saying that civil servants should have the courage to tell us impartially. You follow this. Therefore, this is one aspect I would like to say. Ultimately, of course, the public opinion also should play a large role. Ultimately, it is not the judicial courts to keep democracy in full effectiveness. No, you've got to, people at large, public opinion is an essential element if you want to maintain democracy in this country. That I don't want to expand on this further. The second aspect, the Constitution envisages a strong center. The residuary powers are conferred on the center, unlike in the United States and other federal countries, because they wanted a strong center always too. What is happening today? Today, no single party can command support for running the government on its own. Of course, P.V. Narasimha Rao ran minority government for 5 years. He was an adept in dealing with contradictions. And he knew how to, having known the legal position, how to sort of get these things done. All these economic reforms were introduced by him. I don't want to go into his contribution to the Constitution, which is a separate subject. Now here, what's happening today, you have a coalition government, but you don't know how to run a coalition government. That is the reason A number of economic reforms, etc., which are overdue, have not been introduced because even a single party, let's say, look at Mamata Banerjee, she says, unless you give me additional funds, I will withdraw support. The railway minister who belonged to her party introduced a railway budget. She got angry with him and that fellow was thrown out. How can you run government, central government like this? This is not correct, you know. So the coalition, and today regional parties are holding control, and if this goes on, center will become weak. This is not what was expected by the constitutional founders. Parliaments and assemblies are not able to hold sessions. People go on strike and hold placards and then shout slogans, etc. This is not what is expected of you in these bodies. If you have any grievances, go and express them, but don't hold the house to ransom, you know, like that. This is not correct. It's not correct behavior, constitutional behavior. And look at the abusive language they use against each other. What is the tradition that we are giving to our future generation, to our younger generation? This has to change. This has to change. We have to know what the Constitution says. We have to know what the courts are saying about the Constitution. We have to behave in a democratic temper. Otherwise, this country will go. The courts are holding this thing together, the democracy together. If that also is discredited, there is nothing here. We become like Pakistan. Democracy cannot survive. You have to respect the rule of law. Then only you can grow. And look at the behavior on the roads. Do you find road courtesies on the road? We are the people. All of us are the people. Rules of the road. I in fact once asked the Chief Justice of Andhra Pradesh, then Chief Justice of Andhra Pradesh High Court, in a letter that I wrote to him, saying I'm always in terror. When I go to the court, will I come back home safely? He converted that into a public interest litigation. I should draw the attention of the present Chief Justice to that. Sometime in 2002, or I don't remember when. And then he convened, gave notices to various departments, did something. Thereafter, I don't know because I was not kept in the picture. So what I'm saying is there is this unruly behavior on our part. And all of us belong to that. Unless you improve yourself, your system will not improve. So therefore, please pay attention to what courts are saying. Try to be in accordance. Whatever is unreasonable, arbitrary, the court will immediately strike it down, whether it be legislative or administrative action. You should be mindful of this and then lead the country on these lines. Thank you very much.